Thank you everyone for joining us for this webinar hosted by KCAB Next, where we will be discussing the topic of parallel proceedings in international arbitration. My name is Dana Kim, one of the co-chairs of the KCAB Next Steering Committee, and I'll be giving a brief introduction to the webinar topic and the panelists, as well as touch on what we do here at KCAB Next before handing over the mic to the moderator. KCAB Next is an initiative to provide a platform for the next generation arbitration lawyers to exchange ideas and grow their professional network. We organize networking events, workshops, webinars designed to enhance skills and facilitate collaboration between arbitration practitioners, potential arbitration users, and arbitrators involved in the Korean arbitration scene. The webinar is one such event, and we envision more in-person and online events to come in the near future. Now on to the topic of the webinar at hand, parallel proceedings. The reason why we chose this topic today is that we all know it is one of the most difficult and complicated issues to handle in international arbitration cases. Looks like it will continue to be a prominent issue and cause a headache for practitioners because cross-border transactions involving multi-parties, multi-contract, or chain of corporate entities only continue to grow in numbers. There are many issues to consider. For example, how do we handle them? Should we try to stop parallel proceedings? What is the most effective way to stop it? And should we use parallel proceedings as strategy to put pressure on the other side? Something like that. Of course, it can be a useful strategy tools in the right hands, but it can also lead to chaos if not careful. For example, double recovery, conflicting awards, or duplication of proceedings, or waste of resources. So we are here today to try to clarify the mystique around parallel proceedings with leading arbitration practitioners. The panelists joining us today to discuss the topic at hand, firstly, Wendy Lin, who is a partner at WongPartnership LLP, who is serving her second term as co-chair of the YCR committee. She has been consistently recommended her for dispute resolution work in various legal publications. She was selected one of the foremost highly regarded litigation partners in Asia Pacific under the age of 45 by the Who's Who Legal in 2018. Secondly, Rieu Kim is a senior foreign attorney at Barun Law LLC. Rieu has experience advising Korean and international companies in relation to both contentious and non-contentious matters in Korea and outside of Korea. He has represented clients in arbitration cases before KCAB, ICC, HKIC, AAA, and CAS. Thirdly, Andrew Seok-Han Hong is a vice president at Korea Shipbuilding and Offshore Engineering. Andrew has led many high-profile dispute cases in shipbuilding, construction, and green energy projects involving complex legal and technical issues. Andrew has led his company's successful defense in an arbitration case worth over several billion US dollars and a product liability litigation worth over $1 billion US. He has extensive experience in various procedural roles of major arbitration institutions. Finally, Soo-hyun Lim is the Secretary General of KCAB International. Before her appointment in 2018, she was a partner at Baker Lee, where she practiced for over 15 years and acted as counsel for international parties in numerous commercial and treaty arbitrations under the rules of various arbitral institutions. As Secretary General, she oversees KCAB's international arbitration case management process and leads its public relations initiatives. Sue is a Korean licensed attorney and is also admitted to the New York Bar. Our panelists will be moderated by Kyongwha Chung, an counsel at Covington and Burling. Kyongwha acts as counsel and advisor for both states and corporate clients in complex international disputes, including commercial, construction, and investment disputes. Kyongwha speaks and writes regularly on various topics in international arbitration and mediation. Thank you again for joining us for the webinar today. And now over to the moderator, Kyonghwa.
Anna, thank you very much for your kind introduction. Today's webinar consists of 4 distinct subtopics related to parallel proceedings in the life cycle of arbitration. We will start with anti-suit injunction and anti-arbitration injunction, followed by the interplay between insolvency proceedings and arbitration. We will then discuss strategic considerations between domestic litigation and arbitration, and conclude with handling of parallel proceedings by arbitral institution. The first subtopic, anti-suit injunction and anti-arbitration injunction, are tools sought by parties to decide the venue of dispute resolution to their favor. What are some of the factors to consider in seeking anti-suit injunction and anti-arbitration injunction? Wendy will share her own views on this very interesting topic. Without further ado, I will hand over the mic to Wendy.
Thank you very much, and thank you for the invitation. I plan to spend a few minutes to discuss the tools that are available to all of us when seeking to manage parallel proceedings in court and arbitration. I've set out some of the tools on this slide. The first one, sorry, if I can go to the previous slide, thank you very much. The first option, when court proceedings have been commenced and you're of the view that it should be stayed in favor of arbitration, in other words, the dispute should be heard in arbitration, one option that is available to you is to apply in court for a stay of the court litigation. The other option that will be available to you would be to apply for an anti-suit injunction. In other words, for an injunction restraining the court proceedings from being commenced or continuing. It's usually not necessary to take this step if you already applied for a stay of the court litigation in favor of arbitration. However, there are times that you may have to do so. Just for example, the respondent may have commenced court litigation in its home ground or in a court that you're not very confident in. In that case, you might not want to take the risk of fighting the matter in the foreign court and actually apply for an anti-suit injunction before the seat court or before an arbitral tribunal. Now, what about the reverse situation? What if the matter should be referred to court, but a party has commenced arbitration instead? Now, you can apply for an anti-suit injunction from the court. That is an injunction to restrain the arbitration from being commenced or from continuing. Of course, the other option available for you would be to challenge the jurisdiction of the arbitral tribunal itself. However, just like I explained in relation to anti-suit injunctions, you might not want to put all your eggs in one basket, just in case you do not succeed before the arbitral tribunal. And in that case, you might want to also apply to the seat court for an anti-arbitration injunction. The last option that I've set out there is an application for a case management stay. That is an option you can consider when the arbitration agreement only covers part of the dispute. So there will have to be concurrent proceedings in court and in arbitration. In that case, you can consider applying for a stay of one or the other of the proceeding, pending the conclusion of the other proceeding, on the basis, for example, that this would minimize the risk of inconsistent decisions. But I must say that there are times where you would decide that it makes more sense actually for the matters to proceed concurrently because you want to hedge your risk of losing in one of the forum. If I can go to the next slide, please. Some of the considerations to think about in deciding which option to adopt. I've touched on one, which is, do you really want to put all your eggs in one basket? Here are some of the other matters to take into account. The first one, have proceedings been commenced? If proceedings have not been commenced, the options of applying for a stay in court or challenging the jurisdiction of the arbitral tribunal are out, and you are left with preemptively applying for an anti-suit injunction or an anti-arbitration injunction. Conversely, if proceedings have been commenced, you would have to actually decide what to do pretty quickly. The longer you do not avail yourself of any of these options, the more likely it is that you will lose the chance to be able to make use of them. Just to give you an example, my firm acted for a respondent in an arbitration. When the respondent was of the view that it was going to lose in the arbitration, it commenced a domestic litigation in its home ground in anticipation to stave off enforcement. The arbitration claimant made the choice to only challenge the jurisdiction of the foreign court and not to apply for an anti-suit injunction. It only tried to apply for an anti-suit injunction after it lost in the foreign court, both on the challenge of jurisdiction and on the merits. Our Singapore Court of Appeal said, well, they waited too long to come to the seat court, which is the Singapore court, for help. The longer a party allows the foreign proceedings to carry on, the less likely the Singapore courts will issue an injunction to intervene out of comity reasons. The next factor that I've set out there are the disputes clearly the subject of an arbitration agreement or an exclusive jurisdiction clause. This is important because if the dispute clearly falls within the scope of an exclusive jurisdiction clause or an arbitration agreement, the Singapore courts and the UK courts as well have taken the view that they'll be more likely to grant an anti-arbitration or an anti-suit injunction as the case may be. However, if there is an arguable dispute as to whether there is an arbitration agreement, the Singapore court's approach is, well, the issue of whether there is such an arbitration agreement should be determined by the arbitral tribunal at first instance, giving weight to the competence principle. And in that case, the court is unlikely to grant you an anti-arbitration injunction. The third factor, binding effect of any injunction order obtained. What do I mean by that? Getting your anti-arbitration injunction or anti-suit injunction is not the end of the matter. It is equally important, if not even more important, to ensure compliance. And this is a factor that you should take into account in deciding which option and where to avail yourself of these options. I just give you an example. If you apply for an anti-suit injunction from the seat court or from the arbitral tribunal, but the respondent is not participating and is not submitted to the jurisdiction of either the seat court or the arbitral tribunal, any order you obtain may be just a paper order with no teeth, and you may end up having to go to the home ground of the respondent to apply for the injunction, because that is where you can avail yourself of peremptory orders such as contempt of court if the respondent continues to breach the injunction. The last factor I've set out there is relevant if you are seeking a case management stay. In general, the less the overlap, the less likely you would be able to avail of yourself of such a stay, because the court and the arbitral tribunal would say, well, there's very little risk of inconsistent decisions if we allow both to proceed in parallel. That's my brief overview, and Kyongwha, perhaps we can now take some questions, or you pose some questions to us.
Sure. Thank you very much, Wendy. I know that we have very limited time, but you have used the time very well. And I would like to ask you about any difference between civil law and common law jurisdictions as to the approach to the anti-suit injunction and anti-arbitration injunction. I know that you've been practicing in Singapore, so probably you could share with us your views about your experiences with the Singaporean court, and also what about if you have any, if you have seen some differences between arbitrators from different jurisdictions, whether you see that there's a difference between civil law and common law jurisdiction. Thank you.
Thank you. I'll be interested to hear from the other civil law practitioners here, but in my experience, I find that the common law courts, as well as the common law arbitrators, are more likely or more inclined to grant anti-suit injunctions or anti-arbitration injunctions when the dispute clearly falls within an exclusive jurisdiction clause and an arbitration agreement. I find the civil law courts and the civil law practitioners less likely to do so. They're less likely to want to intervene. And I guess in a sense, that's not surprising, because anti-suit injunction was really a creature or creation of the common law courts. And even then, it took the courts a long time to wrap their heads around the idea that granting such an injunction it's not against comity, especially when there is an exclusive jurisdiction clause or an arbitration agreement, because you're actually just enforcing the parties' agreement. But I'll be interested to hear if that's, the civil law courts and civil law practitioners are increasingly taking that view as well.
Sure, thank you, Wendy. I know that there are civil law lawyers here on the panel, but would there be anyone who would be interested in sharing their views about the civil law jurisdictions approach to anti-suit injunction and anti-arbitration injunction? If not, probably we could come back to that question at our last Q&A session. Another question that I'd like to discuss today about this topic is some of the challenges to anti-suit injunction and anti-arbitration injunction. So for instance, one of the commonly discussed challenges is the lack of effective measure to ensure compliance with the tribunal's anti-suit injunction. So Sue, would you like to share your views on this question, whether that's true or whether there are other challenges to anti-suit injunction and anti-arbitration injunction?
Sure. I'm trying to get my video on, but somehow the host has blocked my video. Oh, okay, I've got an invitation. I'm allowed to turn my video on.
Okay.
The idea was for everybody to be on screen while after the main speaker started finished their presentation, but so somehow the video didn't work. Anyways, yes, thanks for the question. And in fact, I actually want to volunteer for the viewpoint of the civil law jurisdiction, being the civil law lawyer here in the panel. I think most of the court proceedings, if they are filed or if they are commenced despite an arbitral agreement, what happens is that the respondent or the respondent of that litigation would raise what we call a pre-merits objection, a 본안자당변, and the court, they will, once they're satisfied there really is an arbitration agreement in that contract, as per the Korean arbitration law, they will dismiss it without going to the merits. So it will be a very rare occasion. And I don't think I've encountered or heard of any occasion where someone would have to raise an anti-suit injunction in order to stop a court litigation. Of course, there might be a situation where the pending litigation is not in the Korean court, but in the foreign court. But in that case, I think the respondent would try to go to the court of that country and try to stop it there, as opposed to trying to mobilize the Korean court to do something about it. So in terms of injunction, I don't think we see that as often as we would in a common law jurisdiction setting. In terms of the effectiveness of these injunctions, frankly, if there's a party who is trying to not comply with a certain order from a tribunal, I think there's not really much the tribunal can do about it, except for the fact that they hold the power to decide on the merits and issue a enforceable agreement. And therefore, the party who is not complying, misbehaving, would have to pay attention to what the tribunal has ordered it to do. So I think abstractly, in theory, the fact that the tribunal cannot compel a party to follow its order might be problematic, but in a practical view, it takes a very bold party to go against what the tribunal ordered.
Thank you very much, Sue. So Wendy, do you have any additional comments about the compliance issue here? So did you have any experience having a difficult party not complying with the measure, or have you seen any of those parties in your prior experience?
Yeah, I mean, most certainly there are people who will choose not to comply with the arbitral tribunal's order, and they probably think that they would do better going down that path. And it's usually when they don't believe in the merits of their own case. And that is why I said one of the factors to actually take into account in deciding which option to avail yourself of is actually compliance. And you may end up having to actually go to the court where that respondent is based to seek an order. But before you take that step, you should get advice on whether that it's even possible in the home ground of where the respondent is. Because if you're not going to get an order, it might backfire on you. You might be better off getting the order from the arbitral tribunal and just keep repeating to the arbitral tribunal that the respondent is refusing to comply with its order. And most of the times, the tribunals really frown on such behavior.
Thank you very much. Thank you for the practical tips. Because of the limited time, we'll move on to our second topic. And so the second topic is about insolvency proceedings and international arbitration. One of the other parallel proceedings in international arbitration by which we are vexed is insolvency proceedings. Insolvency proceedings are centralized and formalistic. Arbitration, on the other hand, is decentralized, contractual, and party autonomy based. Today, we will hear from you how we should handle these two contrasting regimes. Rieu, the floor is yours.
Okay. Thank you, Kyongwha. Hello again, my name is Rieu Kim, and it's very nice to meet you all virtually, and hope all are staying safe. So today there are 4 topics I will briefly present about the insolvency proceedings and international arbitration. I think I'll wait for the screen, the presentation. Oh, okay, here you go. So there will be 4 topics again. There will be 4 topics I will briefly present today. So the first topic is, so what happens if an insolvency proceeding is initiated in the midst of an international arbitration case? So the first biggest change that you will notice is that the trustee or receiver presents or succeeds the party, the party that filed the insolvency proceeding. This can be quite significant because the trustee or the receiver may not always be the same CEO or the managing director of the party. So you should be expecting to deal with a very different person than before the insolvency proceedings were filed. So this is the first big change that you will you will expect. And then the second change will be that the bankruptcy court approval is required. For example, if the debtor needs to spend some costs, they'll need to first get the bankruptcy court's approval. And these changes will likely require the parties to amend the procedural timetable, which would delay the proceeding because the parties will need to change the procedural timetable in order to align with the bankruptcy steps of the bankruptcy steps. The second topic is that the recovery of the creditor's claims against a party that filed for insolvency. As you know, if the insolvency proceeding is commenced, the creditors are asked to file their claims by a certain deadline. So, and sometimes if you miss the deadline, there will be your chance to recover your claims can be very limited. And once you file or report your claims by the deadline, and the debtor will examine the amount of the claim. And if the debtor and the creditor agree on the filed claim amount, then no further action is actually needed. However, it is often the case that the debtor and the creditor disagree on the amount of the claim. And there's when that dispute starts. And in such case, parties often think that the dispute should be resolved within the umbrella of the bankruptcy court proceeding. However, this is not always the truth. And we will look at the dispute resolution clause, whether there's an arbitration clause or not. For example, if the creditor and debtor agree to resolve the disputes by the arbitration in connection with the underlying agreement, then the creditor may need to file a request for arbitration to recover its claims. Otherwise, the court, if the creditor decides, recover through the court, then the court can dismiss the complaint without reviewing the merits. So that can actually also delay the proceedings, because you'll need, once your complaint gets dismissed by the court, then you'll need to go back to the arbitration and file for the request for arbitration or notice for arbitration. And the third topic is that debtor can become quite aggressive, because once the debtor files for the insolvency proceeding, their main goal is to maximize the recovery of the claim. So they can act quite aggressively and very differently than they did before the insolvency proceeding is filed. For example, they may be calling the bank guarantee or performance bond. And this is again related to the fact that the trustee or receiver may not be always the same as the same person that you deal with before the insolvency proceeding is filed. And this can be quite a surprise or frustrating for the creditors. The next slide, please. And so the last topic is that recoverable amount can be minimal and can take long time. I mean, this is very obvious, because the reason why the key reason why the debtor filed for the insolvency is that because their debt exceeds their asset. So that means the debtor's asset shrink, and the debtor's payment schedule would follow the court-approved payment schedule. So even if your client is a creditor, and even if your creditor is successful in the arbitration case, then the recoverable amount would likely shrink and continue to shrink during the period to recover the award, follow the court approved payment schedule. And also, if the court approved payment is in a mix of cash and stocks, then the form of recovery amount can be a non-cash. So accordingly, early settlement could be an option to save legal costs for your client. So this, I briefly went again over the some of the topics that you can expect to encounter in the insolvency proceedings and international arbitrations.
Thank you, Rieu. Thank you very much. As the last point, you proposed that early settlement could be an option to save legal costs. Given that this is a settlement after the initiation of insolvency proceedings, how early should any settlement be in order to avoid any insolvency related delays?
Okay. Yes, that's a very good question, because I'm sure if you're representing a client who is a creditor, they will be trying to recover debt from the debtor, then they will be very also keen on how much the legal fees they will be spending on this case, because they naturally know that even if they're successful in their case, their chance of recovery can shrink or can be dramatically decreased. So this could be quite I would say a commercial decision. So from the creditor's perspective, you're paying your lawyer, your legal fees out of pocket. However, the chance of your recovery and the amount of recovery can be quite minimum, because due to the fact that the debtor's asset shrink. Yes. Yes.
Okay. Yes. Thank you. Thank you very much. So Rieu has covered during this limited amount of time the interplay between insolvency proceedings and arbitration. When the insolvency proceedings start pending an arbitration, however, a party can become insolvent prior to the initiation of arbitral proceedings and also after the issuance of an arbitral award. In particular, involvement of an insolvent party can create unexpected hurdles to the enforcement of arbitral awards. As some of the parties or some of the domestic national laws, they see that insolvency proceedings as a public policy. And as most insolvency laws prohibit enforcement of awards outside the insolvency proceedings. So Andrew, since you have a lot of experience dealing with different type of parties all around the world, would you like to share any experience dealing with an insolvent party in any stage of arbitral proceedings?
Yeah, sure. All right, I'm turning on my video here. Yes, yes. I'll say such a situation, the counterparty going bankrupt during the arbitral proceeding do happen. It's not rare. It happens from time to time, and we've been in that situation before. The main issue, that arises in such a situation is, as Kim Byung-sun이 already pointed out, and you pointed out, it's the enforcement. From a client perspective, what's the main point of continuing the proceeding if there is a slim chance of recovering our costs or our damages? So it's really more of our internal, decision points, and from an in-house perspective, it's more of the expectation management issue. We need to explain the consequences of the insolvency proceeding to the management, and consider whether we should stop or we should continue and aim for any chance that we get recovered in the separate the insolvency proceeding as well. In one case, we also had a fraudulent conveyance issue because the other party approached to us and asked for kind of separate secret settlement without informing other the creditors about the possible settlement. So that implicated kind of fraudulent conveyance issue on us, and that was a little tricky. But I think the crowd here should be aware of that possibility as well.
Thank you, Andrew. I'm sure it has been quite a headache for you, but it sounds really interesting from the point of view about having the issue of fraudulent conveyance being involved. Because of the time, I'll just move on to our third topic, which is the strategic considerations between domestic litigation and commercial arbitration. So arbitration requires an agreement between parties to initiate the process either prior to or after the dispute. But is arbitration always the best choice for parties? We are arbitration practitioners, but I think we also need to pose this question to us. What are some of the factors to consider in deciding the appropriate venue for dispute resolution? Andrew will be presenting on strategic considerations between domestic litigation and commercial arbitration. Andrew, over to you.
Thank you very much for your kind instruction, Kyongwha, and hello to everyone. In this presentation, I would like to share my experiences and thoughts about what are the factors that we normally consider when choosing between arbitration and litigation. Especially when a dispute is complex, involving multiple parties, different jurisdictions, and different contracts. Before I begin, I would apologize in advance if I would be simplifying things too much here, given the time constraints that we have. I would approach to this discussion from two different angles and timings. One at the pre-dispute contract negotiation stage, and the other after a dispute arises. Because the considerations, I think, are different depending on which stage you are situated. Speaking of the pre-dispute contract negotiation stage first, I'll say that considerations are a bit simplistic at this stage because the interest of the parties involved is typically well aligned. Sign the contract, move on to the real business, and get the party started. Let the money flow. That's the spirit at that time. So what I wrote in the slide, could you go to the next slide? Yes, in the second bullet point. What I wrote in the slide is already simple, but I would say I'll go even further, simpler, and say that while ideally you want to consider many factors, in reality, the discussion usually comes down to mainly one factor, which is neutrality. Whether the dispute resolution mechanism looks like a level playing field, that's the main consideration at that contracting stage. In this light, arbitration tends to be favored because the parties can pick a seat and institution that they view as neutral and feel safer. Of course, I'm speaking in a comparative term. However, this dynamic changes drastically if you need to and can still choose the dispute resolution mechanism after a dispute arises. Could you go to the next slide? The dynamic changes because the interest of the parties would most likely be conflicting. Once the dispute starts, the parties do not want a level playing field any longer. They want to pick a battlefield that gives more advantage to them. So there are many factors that one may consider, and I try to list some of those factors in the slide, as you see on the screen. They are not exhaustive list at all. These are usual suspects, nothing new or special. But I'll just highlight a couple of things here. One, from a company's perspective, in many times, the main goal to initiate an arbitration or litigation is not to get the just and correct legal conclusion, but increase its negotiation leverage so that it can get a favorable commercial settlement. So it's not about justice, it's about money in the end. So to this purpose, to this goal, it is important to take advantage of discrepancies in parallel or back-to-back litigations or arbitrations. Whether that be differences in the procedure, constitution of the arbitral tribunal, or speed and timing of proceedings, or concern or fear of the inconsistent results between those two proceedings. Two, I don't think arbitration is always a better choice, as litigation and arbitration have their own upsides and downsides. For example, litigation can be a better choice if you need more aggressive disclosure of or evidence gathering, or if you want to put pressure on the other party by making the case public, especially in case that the other party is very sensitive about the confidentiality. Or the litigation can still be a better option if you need to consolidate other cases or join other third parties more easily. In this regard, I would say that in my limited experiences, an attempt to consolidate a case or join a third party in an arbitration without previously agreed consolidation or join the clause, it never worked. Again, primarily because the parties' interest would not be aligned at that stage. Some get benefit from the consolidation, some don't. So lastly, I'll share one typical example where a party may want to mix and match arbitration litigation, although these cases come from one common factual scenario. Please go to the next slide. Yeah, some colorful graphs here. To explain the slide you see here, I will start with the subcontractor in the middle. You see the sky blue. The subcontractor has a subcontract with contractor, and the dispute resolution mechanism under the subcontract is arbitration. The subcontractor failed to pay to its subcontractors, colored in orange, because it's insolvent. So subcontractors, they need to recover their money. They need remedy. So they go after the contractor. They initiate a litigation against contractor, demanding contractor to pay instead of the subcontractor. It's not the end of the story. Subcontractor initiates a litigation against contractor to injunct the contractor from paying to the subcontractors, despite the arbitration agreement in the subcontract. So they are disregarding the arbitration agreement, just they file a suit in the local court. In this scenario, an important question arises. Should contractor waive the right to arbitrate and participate in the litigation that subcontractor initiated? Or should contractor file for anti-suit injunction against the subcontractor and proceed with the arbitration? There is another scenario involving guarantor, which does not have the dispute resolution clause in the contract. But for the sake of time, I will forego mentioning about the guarantor. It's already complex situation. So I was involved in this kind of situation before, and at that time, our choice was to file for anti-suit injunction and wait for the subcontractor to file for arbitration. However, we did seriously consider to waive our right to arbitrate because of the local court's broader power to join all parties and the possibility to resolve the issues at one go. That would be very convenient for us. But at the end of the day, we dropped that idea because we felt the jurisdiction itself is a bit unreliable, and the courts may be biased against a foreign party, which was our company. So that was our consideration, and I'll stop here and give the floor back to you, Kyongwha 변호사님.
Thank you so much, Andrew. I would like to hear more about that case, but because of the limited time, I'm sure we'll have other venues to discuss the results of this case. So the last example discussed by Andrew, I think is one of the most representative case, or maybe a typical case, which shows the inconvenience of dealing with multiple parallel proceedings. So Wendy, I would like to seek your views on what could be some of the tips to avoid parallel proceedings before domestic courts and arbitral tribunals in these type of cases.
I think Andrew has mentioned a couple of them, and his company considered them in deciding what to do. The additional option that I would add to that mix of options is the application for a case management stay, which I briefly mentioned in the course of my presentation. We're seeing increasing use of that in the Singapore courts as well as in arbitration when there are related parties or some overlap in the parties arising out of the same factual matrix. What would happen is there will be concurrent proceedings in court and in arbitration, and one of the parties will go to court and say, stay the court pending arbitration because we want to minimize risk of inconsistent decisions. That will usually be contested by the counterparty for all the reasons that Andrew mentioned, right? People want to pick the battleground that they're most comfortable in, and they want to make life as difficult for the counterparty as possible. Singapore courts have been quite pragmatic. I think like with most arbitral tribunals, it really depends on the extent of the overlap. The more the overlap, the more they think it makes sense to stay proceedings pending the resolution of the other. Another option that I've seen arbitral tribunals adopt is no formal stay, but they will fix hearing dates after the conclusion of the hearing of the first proceeding, so that they could, review any judgment or award issued in the first proceeding in the course of their decision for the second proceeding. So that, in a sense, will also minimize the prejudice caused to one side if you stay, an action completely pending the resolution of another action, which could take forever.
Yes, Wendy, I agree with you. Your last point. I also had the personal experience of having the arbitral tribunal fixing the hearing date intentionally after the concurrent hearing date, and I think those are some of the tips that arbitrators sort of use in order to prevent any inconsistent awards. So Andrew, do you have any instances? I'll just move on to Andrew for the next question. Do you have any instances in which your company preferred pursuing litigation over arbitration when you had the choice of choosing between the two? And I understand that you have already discussed some of them, but since we are arbitration practitioners, it would be really good for us to actually hear from in-house counsel like you, and one of the most arbitration users in this arbitration scene. And if so, what were some of the factors that led to pursuing litigation and choosing litigation over arbitration?
I already mentioned about the option of consolidation of joinder power of local court. Other than that, it would be a rare case, but in enforcing the non-disclosure agreement, getting evidence is important. So we need more power from the court to get the evidence out from the other side. So in case involving NDA, litigation can be a better option than arbitration. And on another scenario would be it depends on what the company wants. But there are some times where we just want to prolong the proceedings, and we really do not want the dispute resolved in a prompt manner. Then litigation, local courts usually have 3-tier system. So to take advantage of that feature, we want to go to litigation, and especially some jurisdictions are very well known for very long, prolonged process of the litigation. So that can be a consideration as well.
Thank you so much for sharing all those tips, Andrew. Yes, definitely delay tactics is one of the strategic considerations that's been sort of taken into account when people decide where to go for to resolve disputes. I think it's time to move on to our last topic, which is handling of parallel proceedings by arbitral institutions. As last but not least, one of the issues in parallel proceedings is the issue of parallel arbitrations. As practitioners, we are often faced with the complexity surrounding multiple parties, disputes for multiple contracts and multiple claims. Sue, as the Secretary General of the KCAB International, will present on how the KCAB handles parallel proceedings. Sue?
Sure, if I can have my slides on. There it is. Okay, so I'll use my few minutes, and I'm conscious of time as well, to explain the rules in the KCAB International, the provisions in the KCAB International rules that assist parties or of related disputes to avoid parallel proceedings. So if I go to the next slide. So as a mechanism to address some of the discomfort of having to arbitrate in different cases, many institutions, including the KCAB, include various provisions that allow related parties or related disputes to be heard once, as opposed to parallel proceedings. Currently, the KCAB International rules have Articles 21, 22, and 23, which respectively address the joinder of additional parties, allowing filing of a single arbitration under multiple contracts, and also consolidation of claims. So consolidating different pending cases into one. And I'll explain the requirements a little in more detail in my next slide. Next slide, please. So when someone who's new to arbitration first approach this multi-party, multi-contract issue, it feels very confusing because the provisions in most of the rules are drafted in a way that it's difficult to approach. But I think the rule of thumb that is useful to keep in mind is that, number one, arbitration can only go forward if there is party consent. So if parties consent that this legal relationship, if there's a problem in that relationship, will go to arbitration. That's when arbitration is possible. But this party consent, it seems that there is one consent per agreement and one procedure per consent. So in other words, if there's two agreements, even if it's the same parties, if there are two agreements, then that would theoretically translate to two consents, which would result into two proceedings. And of course, theoretically, that makes sense, but from a party's point of view, if you can review the same facts and review the same issues in the same proceeding, that would add to the efficiency. But at the same time, you can't encroach into the basic tenet of arbitration, which is that you can't force someone into arbitration without their consent of what to arbitrate about. So most rules, including the KCAB rules, they tend to have many requirements that parties must meet in order to either join a third party or to resolve various disputes in one proceeding. I'll go first with the joinder of additional parties. So in Article 21 of the KCAB International Rules, the rules are drafted in such that you may add additional parties if, and then they set the requirements. But in my slide, I've turned it slightly around and put it into a negative mode. And as you can see, the additional parties cannot be joined to an existing proceeding unless, and here we start with the requirements, one of the parties will have to apply. And all the parties and the additional parties either consent in writing to this joinder, or that additional party is already a party to the same arbitration agreement and has agreed to join. So this agreement, this consent, is a basic feature of this joinder. And of course, you have to have a decision by the arbitral tribunal. So even if you meet all the requirements in the proceeding, if the arbitral tribunal believes that joining a third party will result in further delay, they may refuse this application. Next, if we go to the claims arising out of multiple contracts, even if it's the same parties, and even if they have agreed to a transaction which resulted in multiple contracts, in principle, they need to be filed separately as different requests of arbitrations. But if you meet the requirements under Article 22, you may have a single arbitration for all those multiple contracts. And the requirements for that is that first, all the contracts must provide for KCAB arbitration, obviously. The arbitration agreement must have compatibility. For example, if one arbitral agreement requires one arbitrator, whereas the other arbitration agreement requires a 3-panel member, then obviously we have a compatibility issue right there. And also the claims should arise of the same transaction or series transaction. So even if we have party A and party B who have a long and fruitful legal business relationship over 20 years, even if they have 4 or 5 different contracts, if they're done separately under separate circumstances, they are not the same transaction or series of transaction. And for this Article 22, whether you can file one case under one arbitration for multiple contracts, the decision is made not by the tribunal, but by the KCAB Secretariat. We now and then have parties calling us, asking us, can we file this dispute in one case? And then they explain the circumstances. Most of the cases that we hear about don't really meet the requirements of Article 22 and hence end up being filed separately. Lastly, consolidation. So 2 related disputes or 2 or more related disputes cannot be consolidated and will have to run in parallel unless you meet the requirements of Article 23. And the requirement is, first of all, request of the party. And then the other requirement is that the other pending arbitration, which you're trying to consolidate into this arbitration, must be under the KCAB rules. There must not be any appointment on the other pending arbitration, and the arbitral tribunal will make a decision whether to consolidate or not, and they may refuse the consolidation application after they consider the agreements, the nature of the claims, etc. So as you can see, the KCAB international rules have quite a high threshold of allowing cases to be consolidated or filed under one request of arbitration or joining a third party. So next slide, please. So it doesn't mean that because the rules are very narrow, the institution just run cases randomly in a chaotic way. Of course not. The job of the Secretariat is try to find efficiency and ensuring that everybody has consent to the way cases are run, so that related cases will use the least amount of resources in order to reach a satisfactory conclusion for all the parties involved. So just as an example, this is the case one, which you see in the slide. It's a typical scenario that we see. That we can have the same one respondent, but there will be different claimants with different contracts. But these contracts and these claimants have in common with each other the fact that they are in a very similar situation against the same respondent due to the same incident. And in that case, obviously, with that situation does not fall under any of Articles 21, 22, or 23, but sometimes the parties consent and in fact request the Secretariat to appoint the same tribunal for the case, and the tribunal, under the consent with all the parties, would consolidate, either hear the case at the same time, although they have different case numbers, and in fact allow the parties to share the same type of documents and same types of witnesses. Of course, all of this will have to require very careful planning and a definite consent of all the parties involved. But if the parties are active and they're proactive and they think ahead, and the arbitrator also cooperates, there's always ways to find efficiency in those cases. There was a recent case, and this is actually a real case, when there were two arbitrations between overlapping but not necessarily identical parties, but one party ended up, one of the disputes related to a matter that should go automatically to an expedited procedure, while the other was a regular procedure because of the case amount. In that case, what the parties agreed among themselves, and what the Secretary assisted in doing, is that the larger case, which was related, which had 3 arbitrators, went on as it was already pending. And the second case, which related to some of the parties, but not all the parties, what they did was they agreed to appoint as their sole arbitrator the chair of the other arbitrator, of the other arbitration proceeding. So we had a chair who at least had some idea, or had a clear idea of what's going on in both cases. And that apparently helped to minimize a lot of redundancy and helped assist with the efficiency. Like I said, it's really a matter of how proactive parties are and how proactive arbitrators are in finding efficiency in related cases which cannot be consolidated or turned into one case. The final point I'd like to raise is that now that we have parties calling the Secretary and asking, does this work, or what happens if we do this? And some of the questions we get is that if there's a chain of contracts of a larger project, and upstream that chain, we have the Korean party and a non-Korean party who already have a non-KCAB rule, a SIC or a ICC rule.
저 부분 끝났어요, 지금.
But downstream, because the Korean party has subcontracted or bought supplies from another Korean party, they have agreed to, or considering agreed to, KCAB arbitration rules. The question is, do we have to have the identical institutional rules on a back-to-back dispute? Our answer is it's really parties' consent, and because consolidation isn't easy anyways, and because a dispute between a Korean party and their employer who is outside of Korea work on different dynamics, whereas the dispute between the two career parties in the downstream contract, that also are subject to different dynamics. It's not necessary to unify or harmonize all the rules into one rule, and we understand that is how some of the companies are dealing with their contracts. But I guess I should end my presentation with the question of, is it always beneficial to have the same rules which will be consolidated later, or have the other panelists in cases where it's actually easier and more efficient to divide these disputes and handle these disputes separately? So that's the end of the presentation, and I'll be interested to hear what the other panelists think.
Thank you very much, Sue. Sue has posed a very important question to consider. Is it always beneficial to have different but related disputes settled in one proceeding? What are some of the factors to consider pursuing a single proceeding from strategic point of view? And would your approach as a counsel for a claimant be different from that of a counsel for a respondent? There aren't going to be any right or wrong answers, but I think this would be a question about our strategies and advice to our clients. So I would like to pose this question first to Wendy. Wendy, would you like to share your views on this first?
Thanks, Kyongwha. Thanks, Sue. I think the approach doesn't necessarily depend on whether you act for the claimant or the respondent. It's a mix of factors. I think one thing that you take into account is the merits of your client's case. The second is how confident you are or your client is of the tribunal or the arbitration, each of the panel that the dispute is before. And it's a combination of these things. It also depends on how large the war chest is. So I'll just give you an example. If your client doesn't believe in the merits of its case, thinks it has a poor case, really just wants to delay and make things really complicated for the other side, and/or has no confidence in the main arbitration panel, then it is to its benefit to not have all the matters dealt with in one proceeding and to try to make things as difficult as possible for the other side. Conversely, if you believe strongly in the merits of your case, you have a great panel that you have full confidence in, and it will give you a good hearing, then I think one of the things that your client would think about or you would advise your client is to do your best to ensure that is the main proceeding, so that the outcome you get from this arbitral tribunal, you'll be able to use it to persuade other tribunals or other courts to follow the decision of this main tribunal. And it doesn't necessarily depend on whether you act for claimant or respondent. I think it depends on the facts of each case.
Thank you, Wendy. So Rieu, what about your views on this? Would you like to share your views as a counsel?
Sure. Thank you, Kyonghwa and Wendy, for your comments. So I would say I will answer some of the factors to consider pursuing a single proceeding from strategic point of view. Is that I think as many of you agree, the arbitrators are, I would say, very important and crucial in the result of the case. So if you put together all these proceedings as a multi-party, then the first question you should consider, I think, is how much control and how much involvement do you have in selecting the arbitrator? Because if it's just a two-party case, then you have almost a full control over, full involvement over appointment of an arbitrator, unless if it's a three arbitrator tribunal. And intuitively, maybe many people will think that packaging all the cases, related cases, in one case would shorten and would be more efficient. However, based on my experience, multi-party case, it can be very, very complex because of there will be a lot of procedural issues, a lot of motions. Even if you're co-respondents, their interests are not always aligned. I mean, for some for some areas, the interests are aligned, but in some areas they are not. So, there will be many conflict of interest, and it can be quite challenging to to align and coordinate and to navigate those interests, and you'll see a lot of procedural motions to be filed. Yes.
Thank you very much, Rieu. I'm sure this is also one of the topics that needs a lot of discussion, and probably we need more than 5 or 6 minutes to discuss about all of the topics that we have discussed today. I am conscious that it's past 5 p.m. right now, so it's time to wrap up our webinar today. And thank you very much for attending today's webinar. I see that there have been a lot of participants from all over the world, and also there has been some lively discussions about some questions on some of the topics today. KCAB Next will continue with the series of these type of webinars throughout the year. Please stay tuned, and thank you very much again for attending today's webinar. Bye-bye, everyone. Bye-bye.
Thank you, Kyongwha and Dana, for all the hard work. Thank you, everyone.
Thank you.
Bye.
Thank you.
Thank you.
Thank you.